board is not here tonight. So he had a death in his family, so if everyone can remember him, bear with me. We'll get started with the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I believe that Lewis is going to lead us tonight.
Thank you. For those so inclined, please bow your heads in prayer. Lord, as we are gathered here today, we pray for your wisdom to guide us in our discussions, in our deliberations, as we ask questions. And Lord, we ask that you guide us and encourage us in a spirit of amity and friendship. Amen.
You didn't know I'd made you a senator, did you? Or House of Representatives. Look. Y'all bear with me. Okay, so has everyone had a chance to look at the minutes? We have the August 24 minutes. And so those are up for approval. Does anyone have any questions on those? No one has any questions. Would someone like to make a recommendation for approval? We move. Thank you. Do we have a second?
Second.
Thank you. Approve the August 2024 minutes as written. Okay. Have everyone looked at the agenda for tonight? Thank you very much, Fran. Does anyone want to say? Thank you very much, Randy. All right, we're making it fast. I like it. Next up is the division report. We'll start. We have two. The first is the Consolidated Human Services Board Training, Part 2. Now, we are going to use the mic tonight. I think it's really important. So as we have questions, to pass that to make sure that everyone can be heard, okay? So we'll open with the Consolidated Human Services Board Training.
Great. All right. Can everyone hear me okay?
Yep.
Yes?
Yes.
Thumbs up? Is that a thumbs up? Okay, excellent. I cannot hear voices in the room. When you were all talking before, it sounded pretty garbled, but I can hear when you're speaking directly into a mic. So if there is a question, just let me know, and we will stop and maybe you can pass the mic to someone. I'm going to go ahead and share my slides. Let's see. Let's give me just a second. While I'm doing that, I can go ahead and introduce myself. My name is Christy Nicodem. I'm an assistant professor of public law and government at the UNC School of Government. And I teach on the area of social services boards, consolidated human services boards, and the powers and duties of social services directors and human services directors. I think you've heard previously from my colleague Kirsten Malunas on some public health topics. We may have some overlap in some of the training topics that we talk about tonight and in her presentation, but hopefully if there is some overlap, that will be reinforcement for what you learned last time. Can everyone see my slides okay now? Yes? Okay, great. Perfect. All right, so we have a lot of material to go through tonight, so I'm going to move quickly. I understand that you have the slides, or you should have a copy of the slides. And we can always go back to things later if you want to. We can go to questions at the end. You can also email me with questions. I'm going to give you my email address so you have it later. So we're going to try to move quickly through the material tonight because there is a lot to cover here. I want to start out by talking about sort of where your board is in the landscape of social services and public health boards in North Carolina. We have several different models that are allowed by law in North Carolina that have been allowed by 2012 that counties can opt into. The sort of traditional model that was in place was that every county could have a DSS, a separate Department of Social Services, and a health department, and each of those departments had two separate appointed boards, right? The Board of Social Services and the Board of Health. And those were appointed boards. The board hired the director and had sole authority over the director's position, and employees were subject to the State Human Resources Act. That is still the model that is in place in many North Carolina counties today. But in 2012, the options were opened up. The General Assembly opened up the options to all North Carolina counties to exercise these options that are in pink, blue, or yellow. So the pink option is where the Board of County Commissioners acts as the governing board for DSS or the governing board for public health, or they could choose to do both, right? And this doesn't have to involve the consolidation of public health and social services into a single agency. It just changes who is the governing board, right? And in that model, the Board of County Commissioners hires the director. This act. You should see. Then in blue and yellow are the models that involve actually creating a consolidated human services agency, consolidating two or more human services functions into a single agency. And that's what you have in Union County. You have this model I've highlighted here in blue, a consolidated human services agency with an appointed consolidated human services board. In both models, blue and yellow here, regardless of whether you have an appointed board or the Board of County Commissioners serving directly as the governing board, it is the county manager who hires the director, but they have to have the advice and consent of the Consolidated Human Services Board on that decision. The other big difference is that the State Human Resources Act is optional, so counties that create a Consolidated Human Services Agency do not have to keep their social services and public health employees under the State Human Resources Act. They can be solely subject to county personnel policies instead. So those are sort of the key differences between the models. And here's just another way of sort of conceptualizing of the differences as four different models, four different options. Option A is that traditional model. This is all of these examples use social services, but you can imagine the same for a Department of Health. So in that traditional model, you have an appointed DSS board that is separate from the Board of Commissioners, and they directly govern a Department of Social Services, a separate standalone department. In option B, the Board of County Commissioners serves directly as the DSS board. They abolish the appointed board and they take over as the board for the department, but nothing changes about the standalone department. It's not consolidated. Options C and D actually involve consolidation, right? This is where you created a consolidated human services agency, public health and social services, and maybe other human services functions get combined into a single agency. And then you can either have an appointed consolidated human services board, as you have in Union County, or the Board of County Commissioners can serve directly as the governing board for the agency. So lots of different models. I just wanted to give you a sense of sort of where you are situated in the larger landscape in North Carolina. This map will give you a sense of sort of where counties have gone with these options. If you look at a map back from June of 2012 when the legislation changed, it would be almost entirely white. Only larger counties were allowed to sort of have these different options for how they organized social services and public health. But now we really have a patchwork across the state. The counties that you see in pink either have social services and or public health governed directly by the Board of County Commissioners, but not consolidated, so they're not a consolidated agency. The counties that you see in blue and yellow have consolidated human services agencies. The ones in blue, and you'll see Union County in blue, have appointed consolidated human services boards, while the ones in yellow have the Board of County Commissioners serving as the Consolidated Human Services Board. Okay, so with all of that as background, what makes a Consolidated Human Services Agency unique? Why is it different than other departments of social services or departments of health? One is that we talked about the Consolidated Human Services Director is appointed and dismissed by the county manager, not by the Consolidated Human Services Board, which is a big difference from the traditional DSS or Board of Health model. But there is a requirement in the statute that the board provide advice and consent to that decision, right? So the board still has a role, but it doesn't have sole authority in the way that it does in the traditional model. Another difference is that the statute says that the Consolidated Human Services Director reports to the county manager. That's another unique feature, instead of reporting only to the board, right? The statutes also say that the Consolidated Human Services Director has to have approval from the county manager to appoint staff of the agency, though in many cases, the county manager has sometimes delegated this to the director and said, you can sort of do this independently without having to run each and every decision through the county manager. The other big difference is around employees of the agency. So Consolidated Human Services employees are subject solely to county personnel policies unless the county commissioners explicitly choose to keep them subject to the State Human Resources Act. So those are the key differences with a consolidated agency and the traditional model, and we'll flesh those out a little bit more as we go along too. So I understand Kirsten gave you some background on public health, and you talked a lot about public health rulemaking. I'm going to be talking a little bit more about the legal framework for social services, and then we'll dive into more generally applicable topics like the open meetings law and the public records law, for example. So your Consolidated Human Services Agency exists at a unique crossroads of law, policy, funding, and oversight that comes from federal, state, and county government. So the Consolidated Human Services Agency is governed, right, by your board at the county level, and it is providing social services and public health services directly to county residents. And those programs are often funded at least partially through county tax dollars. Its employees are county employees who are hired and supervised at the county level, but it is also supervised by a state agency, right? The Department of Health and Human Services. It has to comply with state law, and it receives some level of state funding. Additionally, there's a federal component here, right? Many of the programs that a Consolidated Human Services Agency administers at the local level are federally funded programs, things like Medicaid, food and nutrition services, and Work First, just to name a few. And all of those programs have requirements set forth in federal law about how those programs will be administered. So a very complex framework here in terms of the law and sources of funding that apply. We can talk about sources of law that apply. We have lots of federal laws and lots of state laws that affect how the consolidated agency does its work. Lots of laws for your director and your staff to have to keep up with and comply with. At the federal level, you have the U.S. Constitution, right, that grants all of us our constitutional rights. It gives, for example, constitutional rights to parents when they are going through an abuse, neglect, or dependency proceeding. There are certain court procedures that DSS has to go through, that the state has to go through before terminating someone's parental rights, and that's because of the U.S. Constitution. We have funding-related program requirements at the federal level, right? All of those economic assistance programs that a DSS is administering, those have lots of federal laws attached to them. We have confidentiality laws at the federal level that may apply to some of the work that your agency does. And we have federal employment laws, right, that apply to the agency's employees. We have lots of state laws that apply as well, including the North Carolina Constitution. We have a lot of statutes about social services. You'll find most of those in General Statute 108A, Chapter 108A of the General Statutes. If you ever want to look for information about social services boards, the powers and duties of a social services director, economic assistance programs, most of those statutes are in 108A. If you're looking for child welfare statutes in North Carolina, you'll find those in 7B. Chapter 7B of the General Statutes is what we call our juvenile code in North Carolina. And it gets a dependency proceeding as termination of parental rights proceedings. You'll also find rules in the North Carolina Administrative Code about social services. And then we have laws that are generally applicable to your board and or to the agency. The public records law, which we'll talk about more tonight, the open meetings law, which we'll talk about more tonight, laws around conflicts of interest, and then for some agencies, the State Human Resources Act also applies, although for many consolidated human services agencies, that no longer applies to their employees. So lots of sources of funding. As I mentioned earlier, some of the funding for social services programs comes from the federal government. So we have grants to states or federal contributions to states. Sometimes those are open-ended, sometimes it's a block grant. And there are always strings attached, right, when we're talking about federal funding. Some of the strings are about administration, how the program gets administered. Some are about eligibility, so who is eligible for the benefit or the program or service. And some are about benefits, right? What is the benefits amount and how does it get calculated? We also then have state funding, some level of state funding. The state accepts federal grants. The state is sort of the conduit for that federal money before it gets allocated out to counties. And we also appropriate some state funding out to counties, right? The General Assembly allocates some state funding to state-funded programs and pays part of the non-federal share of some federally funded programs. And then at the county level, counties also have to pay a county share of mandated social services programs, and counties are required by state law to levy property tax that is sufficient to pay that county share of those mandated social services programs. Counties also have flexibility to pay for non-mandated programs. So they have the flexibility to create their own unique social services programs, even if it's not mandated by state law, and to fund those programs with county dollars. So we have some requirements in state law for what all counties must do. Counties have lots of options and flexibility with respect to how they structure their social services programs and agencies, but there are some sort of minimum requirements. So every county in North Carolina has to have a social services board. That can be a consolidated human services board, like the one that you're on. Every county has to administer certain mandated social services programs under the supervision of a county social services director. A county is required to provide adequate facilities for the social services department to fund part of the cost of social services programs, though a large part of that also gets funded by the federal government, and to comply with state law and policy. We have very similar requirements on the public health side. Right, every county is required to have a local board of health, which can be a consolidated human services board, to provide or contract for or certify available certain mandated public health services, to be accredited by the North Carolina Local Health Department Accreditation Board, to fund part of the cost of local public health programs at the county level, and again, to comply with state law and policy. So what about the state-county relationship? On the social services side, we have what's called a state-supervised county-administered system. You may have heard that phrase before, state-supervised county-administered. It means that the state develops law and policy that shape programs. So the General Assembly develops law that shapes social services programs and funding. The Social Services Commission, which is a rulemaking body, develops rules that shape social services programs. And then DHHS, which is a state agency, develops policy and guidance that shape how local county programs operate. The state also transmits federal and state funding to counties, and to some extent, DHHS supervises county administration. So they provide some oversight of how county social services programs are operating. We'll talk about that a little bit more later. The county level, it is the county that actually administers the programs. So when you walk into a DSS in North Carolina, you are talking to county employees, and it is the county that is responsible for actually carrying out that program or service. That's unique. That is not the case in every state in the country. In fact, it's not the case in most states in the country. Generally, you would be walking into a state-run office when you were walking in to apply for, let's say, an economic assistance program, or you are in need of child welfare services, right? You would be walking into a state-run office staffed by state employees, funded primarily with state dollars. So we have a very different system in North Carolina with a lot more county responsibility. The county is also responsible for hiring and supervising the staff, paying some portion of the funding for required programs, and has the freedom to develop some county-specific programs. Very similar on the public health side, where you have the state sort of developing law and policy, administering some statewide public health programs that are not run at the local level, transmitting federal and state funding to local agencies, and assuring that accreditation requirements are met. And again, at the local level, the county is actually administering public health programs, hiring and supervising staff, engaging in some rulemaking and fee setting, which I think Kirsten talked to you about last time. And again, you have the flexibility to develop some county or district-specific public health programs. So state oversight and rulemaking. In North Carolina, the Department of Health and Human Services is really that agency that provides oversight for both social services and for public health. There are lots of different divisions within DHHS that may touch a consolidated human services agency in some way, but some of the main ones that you'll hear about and that have the most sort of a clear oversight role with respect to your agency would be the Division of Social Services, the Division of Child and Family Well-Being, and the Division of Public Health. Within the Department of Health and Human Services, there are also commissions. These aren't really within the department, but they are staffed by employees from the department who help. Their independent commissions, generally with members appointed by the governor, the independent rulemaking commissions, but DHHS provides some staff support and a location for the commission meetings. The Social Services Commission is the rulemaking body for social services in North Carolina. They adopt rules and regulations regarding social services programs other than the state Medicaid program, which has a different rulemaking body. And in counties with that traditional DSS model, they appoint 1 or 2 members of the county DSS board, but they don't have that role in a county with a consolidated human services agency. And likewise, the Commission for Public Health is responsible for statewide public health rulemaking in North Carolina. So I just want to compare child welfare systems for a minute. I mentioned earlier how unique North Carolina's system is. All the counties, 8 child welfare systems, the ones in the lighter shade of blue are county administered systems. And then we have a few states with stripes here that are sort of a hybrid model between state and county administration. So North Carolina is one of the few, I think only one of 9 states at this point in the country that still has a county administered child welfare system. So in most of the country, this function has been taken over by the state. And there's generally a greater percentage of state funding, and that means that it's going to be state employees who are carrying out those functions as well. There are pros and cons to a county administered system versus a state administered system, and we won't get into all of those tonight. But I think it is worth noting that we are one of the few remaining states who is still using this model of having so much sort of control and responsibility and potentially liability right at the county level rather than the state level. Okay, so state oversight for social services. I talked about this supervision aspect, that we have a state supervised, county administered agency. When push comes to shove, this is really the teeth behind that supervision piece. General Statute 108A-74. The statute says that DHHS must require all counties to enter into a written agreement every year that specifies mandated performance requirements. So it says certain performance requirements that the department is going to meet every year, certain performance targets with respect to all social services programs other than Medicaid. And as part of this agreement, which is often called the MOU, there's also a corrective action process. So the statute says that if the county is out of compliance with the MOU or out of compliance with the law, they're just not following the law with respect to how they run a particular program for either 3 consecutive months or 5 out of 12 months, that will lead to a joint corrective action plan. So the county and the state will enter into a corrective action plan together. And eventually, if the county is not really working its plan properly, if DHHS feels that they have not come up to speed and are not in compliance, that can lead to a DHHS takeover of that local program, or local department, with 30 days notice to the county. There is also in there an emergency takeover authority that only applies to child welfare programs. So this only occurs if something is going wrong with child protective services, with foster care, or with adoption. And specifically, it applies when there is a serious risk, a substantial threat to the safety and welfare of children in the county who receive services from DSS or who are eligible to receive those services. If DHHS determines that's the case, they can come in and take over that program on a temporary basis from the county until they feel that performance has improved or corrected at a level where it's safe for them to withdraw. And in that instance, they can also potentially withhold federal funding from the county as well. To date in North Carolina, to my knowledge, there have only been 3 counties that have had this takeover from the state of their child welfare programs. And each one of them was very serious circumstances involved with respect to their child welfare programs. Okay. Any questions about all of that before we move on to talking about the composition of the board, how your members get appointed, and issues relating to the board itself? No? Hearing none, I'm going to move on. So, who can be appointed to the Consolidated Human Services Board? First, you have to be a county resident. That's the main requirement. You have to be a county resident to serve on the board. Board members typically serve 4-year terms. I say typically because when the board is first formed, when it's first created, the county commissioners have the option to have some shorter terms in order to make a staggered term structure, a staggered board composition. They can have some terms of that initial board be shorter than 4 years. But after that, board members serve 4-year terms. Board members can only serve 2 consecutive 4-year terms. So there is a term limit. People will sometimes ask, well, what does it mean to be consecutive? The statute doesn't define that. Obviously, if you were to serve 1 term immediately after serving 2, if you tried to serve a 3rd term, that would obviously be prohibited. But it's not clear exactly how much of a break you have to have after those first 2 full terms. It's possible, it would be a conservative answer would say you wait a full 4 years, right? That's the cautious answer, is you wait a full term. But it's not clear the law actually requires that. It's possible that you might have a shorter break, maybe 2 years, right? And then maybe there's a vacancy that comes open on the board, and maybe you would be eligible to be appointed again. So state law is not really clear about that. It just says you can't serve a 3rd consecutive term immediately after serving 2 full 4-year terms. And the county commissioner member that is appointed by the Board of Commissioners can only serve as long as he or she remains a county commissioner. So their term limit, their term length is tied to their role as a commissioner. The composition of the Consolidated Human Services Board has to reflect a number of different professions that have to be represented. So you have to have 4 individuals who are consumers of human services. The statute does not define what human services is, which is not super helpful. So it may be consumers of services from your particular agency, but it could also be services from other human services agencies, right? Or individuals whose children receive services from your agency. The wording is pretty broad and vague, so there are lots of different ways that this can be interpreted. The board also has to have represented 1 psychologist, 1 pharmacist, 1 engineer, 1 dentist, 1 optometrist, 1 veterinarian, 1 social worker, 1 registered nurse, 2 physicians licensed to practice medicine in North Carolina. 1 of them has to be a psychiatrist, 1 county commissioner, and then it can also include hired by the board. The statute says that the Board of County Commissioners can have a member on the board who fills more than 1 category of membership, if that person has more than 1 qualification or attribute of membership. So let's say that you have an individual who is both a registered nurse and a consumer of human services. that individual could fulfill both of those requirements. You don't have to have two separate people in those seats. If you have one individual who could fulfill multiple requirements, that's fine. You don't have to have multiple people in those seats. You just have to have all of these things represented by someone on the board, but you could have one person who fulfills more than one of these categories. So here's a few differences with the Consolidated Human Services Board as opposed to a traditional county DSS board or traditional county board of health. The CHS board is larger, the Human Services Board is larger. You can have up to 25 members. All are appointed by the Board of County Commissioners, so that's similar to a traditional county board of health. It's different than a traditional DSS board where you have some members that are not appointed by the Board of Commissioners. Also similar to a board of health, the Consolidated Human Services Board has to have some professions represented on the board, as we just talked about. And on the Consolidated Human Services Board, each member serves 2 consecutive 4-year terms. That's a little bit different than both social services and boards of health, where members serve 3-year terms. Okay, what could potentially limit someone from serving on the board? So we talked about qualifications to serve. What are some potential limits when you're looking at filling a vacancy? What are your limits for who you can nominate? No person can concurrently hold in North Carolina under state law, no person can hold at the same time more than 2 appointed public offices or 1 elected and 1 appointed public office. So the office of Consolidated Human Services Board member is an appointed public office in North Carolina. You are a public official under North Carolina law, an appointed public official. So you can only hold 1 other appointed public office or 1 other elected public office. The exception is for the county commissioner member of the board who is appointed by the Board of Commissioners. That individual serves in an ex officio capacity, meaning that this counts as part of that 1 elected official role. So it does not count as a separate appointed public office. Incompatible office holding. We also have in North Carolina a doctrine against incompatible office holding in North Carolina case law that essentially says a public official cannot hold 2 offices at the same time if there is a conflict between the functions or duties of those offices, or if one office is subservient to another. So another way that this is sometimes said is that an individual cannot be their own boss, right? You can't have someone who is supposed to report to themselves. So this leads to the question, may a board member serve as acting or interim director of a Consolidated Human Services agency? What do folks think?
I'm going to guess no. Does anyone have a?
I think I heard a no on the mic. Is that right?
You did. Mm-hmm.
Yeah. The correct answer is no, because that would obviously be an example of incompatible office holding, right? The director, the board has a say in the director's appointment and dismissal, right? They have to provide their advice and consent on that decision, the county manager's decision to either appoint or dismiss the director. And so a board member cannot serve as acting or interim director of the agency.
Excuse me, can I ask a question? One of your previous slides, you said that the certain professions must be represented. What's their interpretation of must?
What's the interpretation of must?
Yeah, not all of those roles are filled because we don't have applicants in all of those roles.
Yes. So that is the case for many counties across North Carolina. There are, count them both on boards of health and Consolidated Human Services boards. I would say the vast majority of those boards have at least 1 or 2 seats that are vacant because they simply can't find a professional who fills the qualification, who's a resident of the county. The Board of Health statutes allow for a county to appoint a different individual in lieu of some of those qualified professionals. So a member of the general public, for example, to sort of stand in the place of those qualified professionals. The Consolidated Human Services statute, on the other hand, doesn't have that language. So my interpretation and the interpretation of my colleagues has been essentially the county just has to let that seat be vacant. I think the county ideally should continue to be doing a good faith effort to try to recruit those professionals when they become available. But I think it just is a reality for many counties that they might not have some of those professionals who are able and willing to serve. And so the seat just has to remain vacant. Yeah. And there's no particular legal consequence to the seat remaining vacant. So obviously I think, again, the county has to make a good faith effort to try to fill the seat, to try to comply with the law by having that profession represented. But if that's an impossibility and there simply aren't people able and qualified to serve, there's nothing more that the county can do about that other than continuing to have the vacancy posted and continuing to try to recruit someone. Yeah, good question. It does come up a lot. Okay, some other potential conflicts that might keep someone from serving on the board. One is that a board member who is a licensed foster parent cannot be supervised by or accept placements from the county where they are serving on the board. So it's certainly fine to be a foster parent. It's great to have that experience and perspective. But while you are serving on the board, you cannot be accepting a placement of a child into your home from this particular county, from Union County, or be supervised by Union County with respect to your placement, your foster care placement. There's also a prohibition in state law about a board member or their spouse who owns or operates a nursing or adult care home. That individual, if either the board member or their spouse owns or operates that nursing or adult care home, they cannot receive Medicaid or special assistance payments for anyone who is living in that nursing or adult care home. So practically speaking, that really keeps those folks away from serving on the board because obviously that's going to be an important revenue stream for them. There's also a prohibition in state law about someone serving in public office if they have been previously removed from public office by impeachment. So if anyone has ever been impeached from any other public office, they are not allowed to continue to serve in public office in North Carolina, including the office of Human Services Board Member. Likewise, if you have been found guilty of corruption or malpractice in public office, the North Carolina State Constitution prohibits you from serving in public office in the future. Okay, the removal of a Consolidated Human Services Board member must be done by the Board of Commissioners. So the Consolidated Human Services Board themselves cannot vote to remove a member. Now they could vote certainly to make a recommendation to the Board of Commissioners about the removal of a member if they felt that was necessary. They could have conversations about the removal and discuss that with the Board of Commissioners. But ultimately it is the commissioners as the appointing authority that have the authority to remove a Consolidated Human Services Board member. And there are very specific grounds in the statute for why a member can be removed. Those grounds would include commission of a felony or any other crime involving moral turpitude, violation of a state law governing conflicts of interest. We'll talk about some of those later. They typically have to do with contracts that involve the Consolidated Human Services Agency, violation of a written policy that is adopted by the Board of County Commissioners, habitual failure to attend meetings, conduct that tends to bring the office into disrepute. That one's a little bit open to interpretation. Or failure to maintain the required qualifications for appointment. So let's say maybe someone moves out of the county, they're no longer a resident, or maybe they no longer represent the profession that they were appointed to represent. The law also says that that member, before they can be removed, has to be given written notice. That notice has to include the grounds, the opportunity to maybe that's a hearing before the Board of Commissioners, or maybe it's an opportunity to provide a written response. The statute just says they have to be provided some sort of opportunity to respond to the allegations being made against them before they are removed. State law also provides some grounds, and some of this comes from the North Carolina Constitution, grounds for removal of any public official, so regardless of what office they hold. One would be the failure to take the oath of office. So all public officials, including board members, are supposed to take the oath of office. A willful failure to discharge the duties of office could be grounds for removal. Improper multiple office holdings, so holding too many public offices at the same time, as we talked about earlier. And then prior removal from public office by impeachment. So if you get onto the board and someone discovers you've been previously impeached from a previous position, or you've previously been found guilty of corruption or malpractice while serving in a prior public office. Those would all be grounds for removal of a board member. Okay. We're going to move on next to talking about powers and duties of the Consolidated Human Services Board. And again, please stop me if there are any questions, but we'll keep moving for now. This is the legal framework for the board. So there are lots of different statutes you have to look at when it comes. Yes, go ahead.
I thought if you had a chance for a question. You said that a member could hold down 2 positions on the board. How does that work in terms of voting and quorums?
Yeah, so I wouldn't think of it so much as holding 2 positions as it is representing 2 of those categories. So the statute basically says that the county has to have all of those professions, or should have all of those professions represented that we talked about, as well as some of the folks with life experience, right, the 4 consumers of human services. But let's say in theory you had a single individual who was both a social worker and they happened to be an engineer. This is a sort of crazy hypothetical, but let's say you had someone who fulfilled both requirements. That single individual could represent both of those professions on the board. And basically it's saying the commissioners would not have to appoint 2 people, right? You wouldn't have to have 2 separate seats on the board. It would be fine for one person to represent both of those professions and sort of fulfill that requirement. But for voting purposes, they would still just have 1 vote, right? It's still just a single board member. Does that make sense?
Yep.
Okay, great. So you have to look at if you're trying to look at the statutes in North Carolina, you have to look in a lot of different places for consolidated human services boards. The main statute, and the one I want you to all be familiar with as board members, you can go home, look it up, print it out, you can go Google it. If you don't have a copy of it already, is 153A-77. 153A-77. Almost everything we have in state law about consolidated human services agencies and their boards is in this one statute, right? So it's very, very important for consolidated human services boards. But then that statute also says that the board inherits almost all of the powers and duties of a social services board and a public health board. So you acquire all of those powers and duties with a couple of exceptions, as we'll talk about in a minute. So you also have to look to those statutes, right? 108A-9 describes the powers and duties of a social services board, and 130A-39, all of these references are on the slides. 130A-39 is the statute regarding public health boards and their powers and duties. So you have to look in a lot of different places. Essentially, the Consolidated Human Services Statute grants all of the powers and duties of a Board of Health and the DSS Board to a Consolidated Human Services Board, except you cannot appoint the Human Services Director on your own the way that those boards could. You do have a role in that appointment in that you have to provide advice and consent on it, but you can't do it on your own. It also says that the board cannot transmit or present the agency's budget to the Board of Commissioners in the way that they could for a traditional DSS board or Board of Health, but that runs through the county manager instead. The board's relationship to consolidated human services employees. This comes up sometimes both in a consolidated agency and in a DSS and in a health department. What is the role of the board with respect to employees? And there's not really a role for the board. The board has no authority under state law, and this is true for a traditional DSS board or traditional Board of Health too. The board does not have authority to hire or supervise or fire agency employees, to establish qualifications for those employees, or to adopt personnel policies, or to establish a salary schedule. So almost all of those responsibilities lie with the Board of Commissioners. With the exception of authority over the director's position, right, with respect to that appointment and dismissal of the director, which lies with the county manager. And some of these responsibilities are going to lie with the Consolidated Human Services Director with respect to their supervision of employees and how they decide to supervise employees in consultation with the county manager. But the board, generally speaking, and this is true for other boards as well, doesn't have a role with respect to personnel matters within the agency. So powers and duties of the board. 153A-77 provides a long list of powers and duties of the Consolidated Human Services Board, in addition to those social services and public health specific duties that you'll find in other statutes. So it says they have a responsibility to provide advice and consent on the hiring and firing decision with respect to the director. They have a responsibility to plan and recommend a budget for the Human Services Agency. They're charged with assuring compliance with laws related to state and federal programs, so making sure that the agency is complying with the law, recommending the creation of new human services programs if they feel that's necessary in the county, performing public relations and advocacy functions on behalf of the agency, conducting reviews of human services programs, and advising local officials through the county manager. The board's roles related to social services programs. They don't have as substantial of a role as they do with respect to public health. So state law gives very little role even to a traditional DSS board, and the same is true for Consolidated Human Services Board with respect to the decisions the board gets to make about social services programs. And that's in part because we already have so much federal regulation of these programs. There's not a lot of wiggle room for local county decisions about a lot of these programs. But the board can make a limited set of decisions regarding social services block grant programs and the work first programs. They also have authority to review cases of suspected fraud that are related to some public assistance programs, unless that authority has been delegated back to the director, and it's actually the director and their staff handling those fraud reviews, which is the case in many counties that I have talked to, that it is no longer the board who is handling those fraud determinations. It's often been delegated back to the department. The board, if you're interested in learning more about that, I have a chapter. Some of you may know of this book, but this is my book, Local Social Services Boards in North Carolina. I have an entire chapter there on some of those decisions that the board gets to make with respect to social services programs, and in particular, the social services block grant programs and work first, as well as their potential role, if they want it, in fraud determinations. So I would be happy to send that chapter to any of you if that would be helpful. The board also has a limited power to access social services records. So if you look at General Statute 108A-11, it says that social services board members may inspect records relating to the provision of public assistance and social services. But it also says that board members may not disclose any of the information they learn from those records or use any of that information. And that right of access that you see in 108A is pretty heavily limited by some other state and federal confidentiality laws that apply to social services. So for example, it does not extend to child welfare records. So a 1995 North Carolina Attorney General's opinion, which you can find online, concluded that the Social Services Board's right of access does not include child protective services files. And that's in part because those files are protected under the Juvenile Code, General Statute 7B, under an entirely different set of statutes from 108A, and they receive a stricter level of protection. So the board is not able to review that individually identifiable child welfare information. If you're interested in doing a deeper dive on that topic, my colleague Amy Wall, who is now our dean at the School of Government, but was previously in my role and taught on these topics, has written a blog post on our Susquehanna's local government law blog that talks about the board's access to confidential client information, if you want to do a deeper dive there. The board also advising local, so that this statute 108A-9, they are supposed to advise public officials about social and economic problems that are happening in the community, right? And that can include providing advice to the Board of Commissioners. and advocating for plans and policies that improve social and economic conditions in the community. There's a similar role, if you look at the accreditation standards for local health departments, there's a similar role that the board has in advising local public officials about public health. The accreditation standards say specifically that the board should be informing local officials about community health issues, taking action to foster local health department partnerships and interactions with the community, taking action to foster the coordination of resources to enhance partnerships, taking action to foster community input regarding public health issues, and communicating support for the enactment and retention of laws and rules around public health that protect health and ensure safety. So all of these are considered part of the accreditation standards for a local government health department that a board is supposed to help meet. The board also has some responsibilities related to meetings. Right? The board has to meet at least quarterly, though many human services boards choose to meet more often. They certainly can meet more frequently if they want to, but the minimum is quarterly. Either the board chair or 3 members, any group of 3 members, can call a special meeting or an emergency meeting. And the board needs a quorum to do business. And a quorum is defined as a majority of the members. So before you can take a vote or do board business, you have to have a quorum present. You also have to elect a board chair. That board chair serves for a 1-year term, but can be elected again for consecutive terms. I mentioned the oath of office earlier. Every board member should take the oath of office. This can be taken any time between when the board member was first appointed and when they begin their duties in office. That oath of office can be administered anywhere in the state by a number of different public officials, including a notary public. There's a statute that identifies a number of different public officials that can give the oath, and a written copy of that oath signed by the board member has to be filed with the county clerk. If you are appointed to a second term on the Consolidated Human Services Board, you need to take a second oath of office that again gets filed with the clerk. The only person that this does not apply to is the county commissioner member who has already taken an oath of office as a county commissioner and is serving on the board. They don't have to take an additional oath if they don't want to. They don't have to take an additional oath to serve on the Consolidated Human Services Board. Developing local rules of procedure. Your board may already have some local rules. If so, that's great. If you don't, I would definitely suggest adopting some. Topics that I suggest addressing in your local rules of procedure would include the development of meeting agendas. So who's going to be responsible for developing the meeting agenda? Who gets to propose items for the agenda? Election of the board chair. How is that going to work? What happens in the event of a tie vote, for example? Who's going to break that tie? How is that person going to get elected? How long do they serve? Whether you're going to have a public comment period for your meetings. The law does not require Consolidated Human Services Boards to have a public comment period, though some choose to do so, but it's not required. So you could include that in your rules as well. How you're going to handle things like motions or voting, how you're going to handle absences, whether people are allowed to participate remotely, and if so, whether they're allowed to vote remotely. All of these are things that you might want to consider addressing in advance in local rules of procedure. We have a book here from the School of Government called Suggested Procedural Rules for Local Appointed Boards that really provides sort of a template for potential rules that a local board might want to adopt. And then you can sort of modify that language as you want to, as you see fit for your particular board. But it helps to sort of have a starting point for those local rules. Okay, and similar to the framework for the board, we have a similar framework for the director. We have a Consolidated Human Services Director Statute, 153A-77E, but then that statute points to 2 other statutes. It says the Consolidated Human Services Director also acquires all of the powers and duties of a Social Services Director under 108A-14 and all the powers and duties of a Public Health Director under 130A-40. So you have to look, again, just like with the board, you have to look in a lot of different places to find all the powers and duties of the director. Lots of plates they're spinning, lots of balls they're juggling. They have to exercise or delegate the legal powers and duties of the local health director and director of social services. They have to appoint staff, appoint an individual qualifications for a local health director. They also act as secretary and staff to the Consolidated Human Services Board, plan the budget, advise the Board of County Commissioners. They're responsible for investigation and enforcement of state and local health regulations, and they act as an agent of the state with respect to state administered programs or state supervised programs. So here's just a few examples of the many, many powers and duties that the Consolidated Human Services Director takes on when they step into that role. And of course, in many cases, they are going to be delegating these powers and duties to someone else, to a dedicated health director or social services director. In some counties, the Consolidated Human Services Director continues to serve as the health director or serves as the social services director. In other counties, there's a separate director, Consolidated Human Services Director, who has a health director and social services director that reports to them. And in other counties, it's an assistant county manager who serves as that consolidated director with a local health director and social services director reporting to them. So lots of different ways this can be structured and different ways that the Consolidated Human Services Director can delegate those powers and duties out to other people. But these are just a few examples of the many, many responsibilities of the agency and ultimately of the director. Okay. With our remaining time, I want to talk about other legal requirements. So we're going to talk about the Open Meetings Law and the Public Records Law. The Open Meetings Law applies to official meetings of public bodies. And the main thing it requires is notice to the public and access for the public, the right of notice and the right of access. So what is an official meeting? It's any time that a majority of members of a public body, and your board is a public body, so any time the majority of your members are gathering simultaneously in person or electronically to conduct a hearing, deliberate, vote, or otherwise conduct public business. That language, otherwise conduct public business, is the big catch-all, right? Anytime you are discussing, deliberating about public business, your business as a board, and you have a majority of your members present, that's potentially an official meeting, right? So you want to make sure that it is complying with the requirements of the Open Meetings Law. There are special requirements for closed session, so you cannot go into closed session for any purpose that you want to. There are specific limited purposes for which you can go into closed session. So for example, you can go into closed session to preserve the confidentiality of records. You can go in to preserve attorney-client privilege. You can go in to discuss matters involving alleged criminal misconduct. And you can go in for purposes of considering the performance, qualifications, or appointment of a public employee or public official. You cannot go into closed session to discuss members of the board itself or members of other boards. But you can go in if you are discussing a particular public employee or public official within the Consolidated Human Services Agency. If you want a complete list of the purposes that are allowed by law for a closed session, you can go to General Statute 143-318.11. That's a long reference, but it's at the bottom of this slide if you want to see the complete list of reasons why you can go into a closed session. There is a particular process for going into closed session. You have to make a motion in open session. Someone has to make a motion in open session that states the purpose of the closed session, and it has to be one of those purposes that is allowed by law. If you are going in for the purpose of preserving confidential records, you have to cite the law that makes those records confidential. And if there is litigation, if you are going in to preserve attorney-client privilege to discuss a pending litigation matter, you have to identify the parties to that litigation in your motion to go into closed session. Otherwise, you're not required to state anything else other than the general purpose of the closed session in that motion. I also want to point out that closed session has to start in open session. So boards cannot hold sort of secret closed session meetings. They have to at least provide notice to the public that the meeting is happening, provide access, even if the entire meeting will be held in closed session. The public at least has to have access at the very beginning, and then you could immediately go into closed session, right? And the rest of the public would have to leave. But the public still has a right to that notice and access at the beginning of the meeting, even if the entire meeting is going to ultimately be held in closed session. Public bodies also have to create and retain minutes of meetings. I heard you talking about the minutes at the beginning of your meeting. And those minutes and the accounts of your closed sessions are public records, but the minutes and the general accounts from your closed sessions may be withheld from the public to the extent necessary to avoid frustrating the purpose of the closed session. So if it would completely defeat the purpose of, let's say, protecting confidential information or protecting certain personnel information that's being discussed in a closed session, you don't have to respond to a public records request. You don't have to provide those records of minutes for as long as necessary to avoid frustrating the purpose of that closed session. Different types of notice are required depending on the type of meeting. For a regular meeting that falls within your regular meeting schedule, you just have to file that notice of the regular meeting schedule with the clerk to the Board of Commissioners. Any changes to that regular meeting schedule have to be filed at least 7 days in advance of your next regularly scheduled meeting. But otherwise, it just sort of stays with the clerk. It gets posted on the county website, and that's that. You don't have to worry too much about that. For special meetings, you have to provide at least 48-hour notice to what's often called a sunshine list. So people who have requested that notice from the county. That could be anyone who requests it, but often it involves members of the media who have asked to be put on that list. And it has to be posted on the county's website as well. And similar requirements for an emergency meeting. Notice has to be provided to members of the media who have requested it in the same manner as is given to members of the public body. So however board members were notified of the meeting, members of the media and members of that sunshine list have to be notified as well. Notice of a special meeting has to also be posted on a bulletin board at the Consolidated Human Services Agency or a bulletin board at the door of the board's usual meeting room if they meet somewhere other than the agency. And it also has to be posted on the county's website. All right, public records law. True or false, messages sent from your private email accounts are not subject to the public records law.
False.
What do we think?
False.
False.
False, yes. I heard a correct answer. False, and same applies to text messages. Just because it's sent from your personal cell phone doesn't mean it's not potentially subject to the public records law. So, we have a law in North Carolina, Chapter 132 of the General Statutes, that says any record that is made or received in the transaction of public business is subject to public access. So it is subject to a public records request unless an exception applies. It is the content of the record, so it's what is written in that record or what is said in that record, if it's an audio recording or maybe it's visual, right? It's the content of the record, not the location, that determines whether it's a public record. So the question is this record about public business? It's not about whether it's stored on a public device, a government device. It's about whether the content is about public business. So records created on personal devices or accounts are still public records if the content involves public business, including business related to your Consolidated Human Services Board. That right of access requires the county to provide records to anyone who requests them, to inspect or receive a copy, regardless of why they want them, in the medium that the person requests the records if possible, and the statute says they have to be provided as promptly as possible. It doesn't provide a very specific time frame, just says as promptly as possible under the circumstances. And that's really going to depend on the nature of the public records request and the nature of the agency and the type of records involved. There is an important exception, and that is that the county cannot release records when the law says that they are confidential. And obviously many of the records that the Consolidated Human Services Agency works with are confidential. Your agency may deal with protected health information that is protected by HIPAA, as well as some state confidentiality laws. You may have communicable disease information that is protected by state law. All information concerning persons applying for or receiving public assistance or social services is protected under state law. So anything that even identifies someone as receiving or applying for social services, any identification of that person is automatically protected, automatically confidential under North Carolina law. And of course, county employee personnel records, including personnel information about the director or applicants for the director's position, is also confidential under state law. So none of these records can be disclosed to the public pursuant to a public records request. Remember that we also have records retention schedules in North Carolina that apply to local governments. So you should have a records retention schedule for your county that applies to your board. So there's a general local government retention schedule that generally applies to the Board of Commissioners, but also applies to board minutes, for example, of other appointed county boards. And there's also a separate records retention schedule for public health and for social services. So you can find copies, blank copies of those at the North Carolina Department of Natural and Cultural Resources website. I have a link to it here, but you should also have a signed copy on file of those schedules in your county as well. And basically those schedules control when you can delete certain documents, when you can delete certain emails or text messages, whatever the record may be. The schedules have particular categories of documents and then say how long those documents have to be retained before they can be thrown away or deleted. So be careful not to delete emails or other documents that relate to board business before figuring out whether you're allowed to do so. Okay, we'll also briefly discuss liability. I think Kirsten may have talked a little bit about liability as well. A lawsuit against the Consolidated Human Services Agency or against the board is really a lawsuit against the county. So the county is going to be the actual defendant in that lawsuit. In some cases, the State Tort Claims Act could also involve the state as a defendant, but generally speaking, these lawsuits that involve the actions of the agency are brought against the county. Same with respect to actions involving the board. They're generally brought against the county. An agency, a Consolidated Human Services Agency, is not a separate independent legal entity that can sue or be sued. So it is part of county government and it's the county that can sue or be sued. If you are named in a lawsuit as a board member, which is extremely rare but occasionally happens, if you are named in a lawsuit, if you're named in your official capacity or the director is named in their official capacity as a defendant, that means it's really the county who is being sued. So it may have your name in the caption of that lawsuit, but it's ultimately the county that is on the hook. They are seeking damages from the county, monetary relief or some other type of relief from the county itself. If the caption says, names you in your individual capacity, says you're being sued in your individual capacity, whether that's the board member or it's a director or it's some other county official, that means they are going after you personally, right? They are trying to recover something from you personally. And the types of immunity that apply are going to be different depending on whether you are being sued in your official state is really the county. There is a doctrine in North Carolina known as public official immunity. It provides protection in individual capacity lawsuits, so those lawsuits that are trying to go after you personally for alleged negligence under state law. So it does not apply to violations of state or federal employment laws, for example, does not apply to a willful violation of the law, something that is willful or malicious or criminal. But if the allegation is negligence, just that you were negligent in your duties, it will provide protection from liability in those types of lawsuits. You can potentially face a lawsuit under the open meetings law, so anyone who believes that a board has violated the state's open meetings law can file a lawsuit against that board in a district or superior court. The court can issue an injunction that essentially stops the board from threatened or continuing violations of the open meetings law, so it says you can't violate it in the future. And any action that was taken by the board in violation of the law So let's say you held a vote or made some other decision at a secret meeting where you didn't provide notice or access to the public, that action can be declared null and void by the court. If a board member knowingly or intentionally violated the open meetings law, the court could also order that member to personally pay all or part of the plaintiff's attorney's fees. On the other hand, there are no plaintiff's attorney's fees owed if the board member or the board as a whole followed the advice of an attorney regarding the board's actions. So I would say in situations where you are unclear about the open meetings law's requirements, unclear about whether you can go into a closed session, for example, or what sort of notice has to be provided of a particular meeting, make sure you're consulting with an attorney first. Because if you are, then even if you make a mistake, if you follow the advice of an attorney, you are not going to owe any attorney's fees in this type of lawsuit. There's also the potential for criminal liability. Hopefully this will not be the case with any of you. But these are some reasons why a board member might be subject to criminal liability. One would be unlawfully disclosing confidential information. That's a misdemeanor in North Carolina. Disrupting an official meeting of the board, also a crime in North Carolina. Threatening or assaulting other board members, the directors, or employees of the agency. Embezzling county funds, willfully failing to discharge your duties as a board member, or unlawfully receiving a direct benefit from a contract that involves the Human Services Agency. Obviously, lots of potential consequences of agency misconduct. We're not going to go into those for the sake of time, but obviously lots of reasons to try to avoid a potential lawsuit, both with respect to the actions of the board and with respect to your role in providing oversight to the agency itself. All right, in our last couple of minutes, I know we're short on time, I'm going to talk briefly about ethics. The basic principles with respect to ethics when it comes to serving on an appointed board is make sure that you are acting in the public interest and for the public good, not for your own private benefit, right? That should be a guiding principle when you're acting as a board member. Generally speaking, avoid using your position on the board to promote partisan political platforms or parties or candidates. It should be a nonpartisan position on the Consolidated Human Services Board that really serves the entire county and all of its residents, regardless of political beliefs. You also cannot use your position to influence the director to hire, promote, or provide preferential treatment to your spouse or to any other relative. And in some cases that may violate the law. That influence over the director may violate the law, as we'll talk about in a second. The statute in North Carolina that applies to your involvement with contracts, this is the main conflicts of interest statute for public officials. It's in our criminal code in North Carolina, 14-234A. I suggest taking a look at this at some point, but there are three basic things that this statute prohibits. First, you cannot be involved in making or administering a contract on behalf of a public agency, like your Consolidated Human Services Agency, if that contract provides direct benefit to you or your spouse. So that is a Class 1 misdemeanor and a void contract automatically. You also cannot be involved in attempting to influence someone who is involved in making or administering a contract. Cannot attempt to influence that person, even if you are not directly involved in making or administering the contract, if there is a direct benefit to you or your spouse under that contract. That's also a Class 1 misdemeanor. And finally, you also cannot attempt to influence someone involved in making or administering a contract in exchange for some sort of gift or favor or promise of future employment, right? So this could be money, it could be vacations, it could be other types of gifts, but you cannot attempt to exert influence over someone involved in making contracts or making decisions about contracts in exchange for gifts or favors, even if you were not benefiting at all directly from the contract. That would also be a Class 1 misdemeanor. So these are really the big prohibited activities when it comes to board, but they benefit from a contract if you are involved in making or administering that contract. It's illegal to attempt to influence a person who is making or administering a contract for your benefit. or to solicit or receive any sort of gift or reward for recommending or influencing the award of a contract by a public agency. If you are interested in exploring more, we have a website. This is a website I created for the School of Government called the North Carolina Human Services Hub. There's a whole tab here for governing boards that has governing board information. There's also a tab specifically for consolidated human services agencies if you would like to explore more information. I would also suggest subscribing to our blog. We have a blog that I've linked to here below where we do posts for local government. If you search under my name, you can see posts that I've written, which are often about social services topics and other topics involving local government, sometimes about consolidated human services. This is my email address. Please feel free to reach out to me. It's one of the things we do here at the School of Government is provide consultation and information about the law to public officials and public employees and anyone who's interested in learning more. Always happy for you to reach out to me, set the time to talk, or just send me a question via email, and I'll do my best to get back to you quickly. So with that, I think we are at time. If anyone has any questions, I'm happy to stay on for a minute.
Does anyone have any questions for Kristen? I don't see anyone, but thank you very much. Very informative.
Yeah, happy to help. Have a good night, everyone. Good to be with you.
Thank you. Thank you. Okay, everyone, we're going to move on to our next division report, the approval of requested public health clinical service fees.
Thank you. The fees that we have listed there, the first one that's listed is one that was actually approved at last month's meeting. So it doesn't obviously need to be approved again, but the other two fees that we have are for administration fees for RSV virus monoclonal antibody, and those two fees are included in the spreadsheet that you also have attached to that. These are new fees that are associated with, I believe it's Beyfortus, which is a new medication, particularly for young children. We welcome your approval.
Dennis, what's the pilot program?
And the reason for adjustment.
Pilot program, which is, where are you reading? Oh, in the reason for it. It really is not a pilot program.
It looks like it's left over from
I think it was left over from
some behavioral health
previous.
CPT codes that we were adding.
Yeah. Yeah, this would not be a pilot program.
Okay. Does anyone else have a question? Anyone has a question, would someone like to make a motion?
I'll make a motion to approve.
Do we have a second? Meg has a second, thank you. I believe that is all of our business tonight. We're going to hear from... What was that? Would you like to?
Mention this. Megan just noticed this on the recommended fee by department. I believe that the 2238 fee that goes with code 96380 should probably be flip-flopped with the 2841. Like 96380 should have the higher cost because it includes counseling by a provider. The Medicaid reimbursement and the commercial reimbursement look like they're correct, but those two look like they got reversed.
And that's a formula, right?
It is.
Yeah.
Yeah, it looks like they just put the wrong amount in the wrong box.
Two errors being found on this. I'm concerned for the rest of the data in the table. Can this be checked and brought back at the next meeting?
It can, it will just delay implementation of,
Can someone check and make sure the rest of the data is correct rather than piecing it together?
but what I'm hearing is that
I believe it's the correct
the correct
cost.
information, it's in
The
the
two
wrong.
boxes were just inverted.
70%, was that the formula?
30% or something?
30% of the Medicaid rate.
Mhm.
Yeah, I mean, I know that part is correct.
So that would be just inverted. Yeah, the numbers would. So, with that motion, with that question, and our vote, how would we proceed with that? See if anyone else agrees with that.
That's up to you guys in terms of if you,
So as Meg explained, she had concern with there being two errors. Does anyone else have concern with that and would like to delay or retract that vote?
Well, let me just say, I can understand the reason for wanting to delay it, to do it later. I think what you see, one, the pilot program was just an oversight of something that was a holdover from it. So that part, I know that part is accurate. The other figure is just a flip. So it depends on what you gauge the magnitude of the mistake in terms of whether you want to delay that. We can certainly bring this back on a clean spreadsheet if that's what folks prefer to do. It will be what you have just heard though.
and I'll add one other thing. If you all choose to move forward with this, we will also take it to the Board of County Commissioners. We'll obviously, for sure, have this updated, and so the agenda item that will go before the Board of County Commissioners will not have the inverted numbers, but they will be in their correct location, and will not mention anything about the pilot program.
And it's not official until they.
It would not be implemented until after they have passed it. Yes, that's correct.
Yeah, that is a good point. Because, I mean, ultimately, this is recommending fees to go to the commissioners, because they ultimately are the ones that have to adopt the fees and put it on the fee schedule.
With that being said, can we put those numbers and approve it? You okay with that?
So we have an agreement on that? Do we have a second on that? And now we'll go to the directors.
I don't have a whole lot. We talked about the TV case investigation last month. So far, that's gone well. Fortunately, we've not had any positives that have come out of that, and we're getting close to closure of that investigation. So that part is good. The behavioral health initiative that we talked about in child health last month is starting now seeing patients in child health, so that's been good. Starting to be sort of steady for that, so We look forward to seeing that grow. And that's really all I have right now.
In business operations, just a reminder, public health accreditation is happening next month. October 16th will be the site visit with the state. And Carla will lead us with that as our agency coordinator. And she did ask me to mention, she's got some documents for folks that came in late to sign pertaining to your orientation as board members that we do need for accreditation. So if you have not signed one of those for her and you're new, please make sure we get that because they will be checking every detail. So thank you.
I don't have anything.
I have a question. Since you're retiring, have you received applications for a public health director position?
Yes, is the answer to that. And we have received a number of qualified applications. The interview process is underway. And so hopefully we'll be able to provide a more detailed update about that at one of the next 2 meetings. And our hope is to be able, obviously, to select a candidate and have someone to be able to have a smooth transition before Dennis retires at the end of this year. Thank you. Thank you. So that was one of my updates. The other thing that I wanted to mention is that we will have 2 upcoming board vacancies. So Meg Harkins is filling our engineer position, and Meg has served 2 appointments or 2 terms, and so as we learned this evening, there will need to be a gap in that service, and she cannot serve a 3rd term immediately. So that position will be posted by the clerk to the Board of County Commissioners in the coming weeks, as well as Lisa Kerner, who fills one of our other person positions, and Lisa has only served 1 term, so will be eligible for reappointment. So for those and the other positions that are vacant, if you know someone that you think would make for a good member, especially for the engineering position specifically, we're hopeful that Lisa will reapply if she chooses to do so. And Meg, maybe at some point in the future that you will as well. And I also wanted to mention that, so our next regularly scheduled board meeting is on October the 14th. And then we would have a regularly scheduled meeting in November. That will be November the 11th. At this point, obviously, we don't have agenda items that far ahead typically. And so what we'll do is we'll work with our chair and vice chair to see if there are any agenda items that would be anticipated for that meeting. If there are any, then we will ask you guys to take action to move the meeting date from, typically we would move it from Monday to a Tuesday. Or if there aren't any, you also can make the recommendation to cancel that meeting. So we'll be bringing something back to you for action at next month's meeting. And
Which month would we move?
November, November, because it's Veterans Day. And we'll discuss that next month in October. I just wanted to go ahead and mention it now. And also just want to, again, share our condolences to Mr. Ford's family and ask you to keep them in your thoughts and prayers.
I just have one update for transportation. Last week, we changed the age to ride from 18 years or older to 0 to 15 with a parent or guardian. And then if you're 16 and over, you can ride as an adult. Thank you.
No comments, Madam Chair.
I believe that's everything then.
Motion to adjourn.
Motion to adjourn? Does anyone? Make a motion to adjourn. Thank you.
Yeah, but it's just so exuberant over there. What was the other?